All right, so we are here to discuss our newly approved in October, Standard 5, which is independence from the judiciary. This is probably the standard I've gotten the most questions on over the last year and a half to 2 years. The compliance planning process this year starts next week, and at this point, I think I've got a planning meeting scheduled with every single funding unit in my region, but we're going to be planning for standards 1 through 5. And those plans, you'll hear me say this over and over as we meet throughout the month of March and email with you all and talk on the phone. The plans are going to be due no later than April 27th. And we're going to be using our new eGrams grant management system to submit the plans. And it's my understanding that April 27th, it's going to shut down at 5 p.m. So you won't be able to submit late. So just a heads up on that. So I like to kind of break Standard 5 down and simplify it for folks, just because I think it can get confusing. This language that you'll see on these slides about Standard 5 comes right from the MIDC website. But if you think of Standard 5 in terms of its ultimate goal, which is to put the prosecution and the defense on a level playing field, then it's not as overwhelming, I don't think, and when we think about planning. So the ultimate goal is here on this slide. The system and the lawyers serving under it should be free from political and undue budgetary influence, and both should be subject to judicial supervision only in the same manner and to the same extent as retained counsel or prosecution. So again, it's all about equality here, all about the level playing field, as I'll refer to it. So what does this look like in terms of implementation? And I kind of broke this down, and in my own mind it helps to break it down into 2 main components. The first of which has to do with the lawyers. So when we talk about the selection of lawyers, we're talking about the folks who are delivering the defense services in your system, and also the payment for their services. So who gets to be on the list or the contract or a member of the PD office? Judges and the judicial staff no longer have, with Standard 5 in place, won't be involved in choosing those lawyers. They can't be involved in that process anymore. And also the payment for the lawyer's services. So if you are working in a system that requires the lawyers to submit their monthly invoices to the court, that will have to change in your fiscal year 22 plan. So again, the first component is focused on the lawyers. The second component is all of the other expenses and services that go into providing effective assistance of counsel. So we, for example, investigative services and experts. If you are working in a system that requires your defense attorneys to file motions with the court to get expert and investigative services, that is something that will have to change with the implementation of Standard 5. The State Bar, just a note here, has gone a step further and said that both of those functions, since it's not the court anymore, it's not going to be the court that's reviewing and approving the attorney invoices, and it's not going to be the court that's going to be reviewing requests and approving requests for experts and investigators. It does have to be, those duties do have to be fulfilled by a licensed attorney. And the rationale behind that opinion is rooted in Michigan Rule of Professional Conduct 5.4. I've noted it there. You can write it down and take a look at the rule in its full text, but basically the State Bar is saying, listen, we don't want non-lawyers conducting work that lawyers with the special skill of a lawyer should be doing. So what can the courts do? And again, I want to break this down because I've gotten some phone calls and emails from places in my region that think judges are just out of it. They're hands off. Everything's all up to the MIDC now, and that's not the case. And we still want courts to be involved. First, if the court chooses, it can still make the determination of indigency. Our standard for indigency is still pending, and if the court chooses to maintain that duty, it can. Also, if it does make a determination that a person is indigent, qualifies for a court-appointed attorney, the court can make a referral to the appropriate agency then for that person to have an attorney appointed to them. So basically, as an example, if you were working in a public defender office model, the court could refer that person to the public defender, and the public defender would assign an attorney. And it will work the same in managed assigned counsel models and models that are still working under contracts that may have a lead attorney in place. We don't want judges cut out of our process completely. We want their input. We want them to participate. Even as we plan for fiscal year 22, I'm letting folks know, listen, this is a major change with this Standard 5. And if you want to invite judges to our planning session, please do so. Please feel free. It will look a little different for some people in that we can't have judges signing off on plans anymore, or submitting plans, or their staff for that matter, or assigning the contracts with MIDC. But we definitely still want judges involved in our process, and we value their input. So what does this mean for your system? So like I said, I've got a planning meeting scheduled with every funding unit in my region for March. And I am certainly willing to have more than one meeting with people. I just wanted to get an initial one on the calendar for everybody. And if you need more than one, I am happy to help out with that. We're going to be, when we sit down to do the plan, we are going to be taking a look at the plan application itself. We have posted an updated plan application and an updated cost analysis. Those forms are on our website on the grants tab under the planning for fiscal year 22. And we're going to be walking through the plan application one standard at a time, taking a look at, you know, for the standard 1, do you have any lingering needs? How is compliance going with the standards? Are there any items that we need to tweak or take a second, third look at? But most of our time is going to be focused on standard 5. And we're going to ask a lot of who questions, right? Because functions that the court used to do, now we need to know who is going to do them. So again, who is going to act as your appointing authority and be responsible for selecting the lawyers that are going to deliver the defense services in your system? Who is going to be the attorney who will review and approve the attorney invoices every month or when those are due? Again, it can no longer be the court. And then who will review and approve the requests for experts and investigators? Because again, we won't have the court hearing motions on those issues anymore for our indigent folks. So what does this look like in practice? You know, a lot of people have found this overwhelming because it's going to require a lot of change on their end. But the good news is there are already models available for you in Northern Michigan. And so I can share some of what those ideas, what those models look like. We've got public defender models that have implemented Standard 5. And those could be either county employee models, or we've got nonprofit models in Northern Michigan. Also, we've got independently managed assigned counsel systems that have an attorney administrator who administers a roster of attorneys. And that person is the person that administrator is the person who is the go-to, the point of contact for all things MIDC. So that's the attorney that's reviewing those invoices. That's the attorney that the other attorneys working in the system are making their requests for experts and investigators to. And we also still have some contract systems in Northern Michigan. And those systems have chosen to incorporate an attorney administrator, or in other words, a lead attorney. the lingo that you use, we don't dictate what you call who, but these are just some frequently used titles that I'm using here on these slides. I did get a question about that yesterday. So as we meet with systems individually, we'll walk through what you can call that when it comes to writing your plan. So don't stress out about the lingo. And in addition to these models, we've got some systems that have also regionalized. So we've got regional public defender models, wherein one funding unit is the primary funding unit for receiving the grant funding, but it covers more than one county. We've got a regional managed assigned counsel system model in northern Michigan, where we've got an attorney administrator who is managing 2 counties within the same circuit. So as you sit down with your other stakeholders to come up with your plan for fiscal year 22, a good question is, does regionalization make sense for us? Do you already share judges? Are you already in the same circuit? Do you share lawyers already? Do you already share resources that the clients will access during the course of being represented by the defense counsel? Regionalization is helpful because it allows processes to be streamlined. And so you've got attorneys within the same circuit all doing the same thing. They're not having to do it this way in one county and another way in another county. So where do you start? Well, first of all, with me, and that's why I've scheduled all of the planning meetings. And certainly I want people to feel very welcome to call me, email me. We're all busy, right? If I don't answer the phone, leave me a voicemail. I will call you back. I want to be accessible to you to help you through this process. So please, if you need something, reach out. If I don't have the answer, I will get it from you. I work with very talented coworkers who are super smart people, so I can get the answers if I don't have them. And also another great resource is the MIDC website. And I think this is underutilized by a lot of folks. There's so much information there, especially on the grants tab when it comes to planning for fiscal year 22. We've got a newly approved by our commission set of FAQs for Standard 5 that I am encouraging people to take a look at before the planning meeting with me. We have a newly revised and updated grant manual available on our website on the grants tab. Again, we've got the planning documents, the plan application for fiscal year 22, and also the cost analysis. And the plan application is watermarked. You submit via egrams, but it's still a great tool for you because you can go ahead and fill everything out ahead of time. And then when it comes down to sitting down to input all the information into egrams, you've got it all right in front of you already. If you are a system that is potentially considering changing your delivery model, so maybe you are a contract system and you are considering switching to a public defender's office. We've got a document that I frequently refer people to on our resources tab on our website called Delivery System Reform Models, Planning Improvements in Public Defense. It's a very helpful document because it walks through each delivery system model. And in the case of a public defender's office, it has 2 or 3 page mini, I'll call it feasibility study in that document. And what that helps you do is kind of lay out the factors in making the decision to start a PD office. So looking at costs, caseloads, and quite frankly, if you are considering that model, that's one of the things I'd be asking you for, would be some form of feasibility study, just so that I know that it's well thought out and it makes the best sense for your system and also for clients. systems don't have to spend a lot of money and hire someone to conduct a feasibility study. That 3-page piece that we have in that document is sufficient. I also get a ton of questions about CLEs. We've got CLE information on our website. We've got information about quarterly reporting, our commission meetings, the minutes, upcoming standards, everything is there. So I would encourage folks to definitely go there and use that. Take a look, poke around before our planning meeting. So in terms of Standard 5 specifically, are there any questions that you have right now for me? Anyone? Janet?
I got one.
Chad? Okay.
Do you have, maybe you answered this, but is there like specific language we can use that we're going to copy from, that I could copy from and not reinvent the wheel on regarding preparing that Standard 5 language?
No, I mean, we don't have any canned language, but you're halfway there already, right? So,
oh, well, yeah, we basically do it already, but.
Yeah, that is something. So if you take a look at the plan application this year, we updated that, Chad, and okay. It walks through, it looks a lot like last year's plan. I'm holding it in my hand here, just taking a look at it, but it asks for pretty specific information. You know, what's your process for this? How do you do that? And I think if you just answer what you're doing already, you'll be fine. In terms of Standard 5, you're making the appointments already?
I'm making the appointments. I'm determining the experts, investigators. The only issue, and my judges are on board with me appointing people and determining agency even.
Okay.
But I don't want to reinvent the wheel with how I would write that out.
Well, because it's an individualized plan for Lewis County, I think you'll be fine with the questions are very leading here. So I think it's just how will attorneys be selected to provide adult indigent criminal defense services in your system? Please describe any eligibility requirements needed by attorneys. I mean, it's pretty black and white. Who will review and approve attorney billing? Who will approve requests for expert and investigative assistance? So I think you'll be all right. If you get stuck, give me a holler, but if you're already doing it, you should be in real good shape.
We're pretty much doing it, and I have good judges. Well, obviously the judge that was just on MIDC, so.
Okay. Yeah, right.
We're doing
I'm hearing great things about him, by the way, too. So
he's going to be a good judge.
That's great. We're real concerned with just, you know, detail as to your policies, your procedure. How are you notifying your lawyers within your system of the policies and procedures, that kind of thing. So there's no real canned language I can give you. Every system is different.
All right.
Good question. Are there any other questions that I can help with right now? So if you're on this call and you're not sure when your system planning meeting is and you want to know, send me an email and I can send you the Zoom link if it's something you'd like to participate in. Also, like I said before, please feel free to invite judges and other stakeholders that you think, you know, might need to be kept in the loop or have something to contribute. Certainly, the more the merrier, especially for the initial meeting. So I see in the chat a request to send the slides. And so I will definitely do that. And I will do it after I end the meeting. So if I missed anybody, zip me an email tomorrow and I will send it for sure. And I really appreciate everybody taking the time. just to pop in. I know it's the end of the workday, and I tried to keep it short, but just kind of wanted to try to alleviate some of the anxiety I've been hearing about making this transition. I think we've got a lot of good resources to help you through this process, and I think it's going to be great once we get rolling with it. So if there aren't any more questions, I'll go ahead and end the meeting.